I think there's this indefinable quality, really, of what makes a good litigator. And it's a little pizzazz, it's a level of comfort, an ability to speak spontaneously and sound interesting. And so when you see it, you just recognize it. Know your material and work with your material, but don't just stick to that. If you practice just the art of cross-examination on anything, or making an opening, making a closing on different facts completely, not just the facts that are in front of you, I think you'll be better prepared when you come to do this particular moot, because it's a skill set. Lawyers will do this. Before, I always did as a lawyer in preparing a case. Before I would argue the case, I would think up everything I thought my opponent might possibly say and prepare an argument that I would advance. And I would do that whether the opponent had raised that argument already or not, because you don't know what's going to happen in the heat of the moment in a courtroom. An argument just pops out. Sometimes it's the judge that asks you this point, even though your opponent hasn't raised it. And so you need to be prepared. So that's not in your notes. It's not, you haven't got your scripted answer to that, but you've thought ahead what things can come up, and you're prepared to give an answer. So the worst thing that can happen is a question is asked, either from the bench or something is raised by a witness that you didn't anticipate, or another counsel says something, and all you can do is say, because it's not something you've thought about. You need to be able to be flexible. You could rehearse the whole thing, memorize it, deliver it. Reading is the worst. If somebody just has it there and they don't even look up and they don't make eye contact, they're just reading from a script, that's really the worst. Second worst is you've memorized it and you do look, you watch, but you look at the judges, but it still sounds like you're doing a rehearsed piece, like as if you're in a performance, like a play. The best are those students who know their material, have notes, they know where they're going to go, but they don't stick to it. They are adaptable. They sound natural. They're able to weave in things that have just happened, and those will be the best students. Well, it's a difficult question to just answer off the top, which teams stand out. Often it's the ones who can simply roll with the punches. I think the mistake that a lot of teams make is in almost over-preparing. You need to really, really know your material. You need to know the facts and be completely conversant with all of the detail. But when it comes time to be asking questions or cross-examining, and in particular making your closing statement, if it sounds rehearsed, it sounds artificial. And so the students that tend to do the best are the ones who don't stick to a prepared script and are adaptable. So sometimes that's because they get to be adaptable because something happens and they have to roll with it. And other times it's because they're just naturally that way. So I guess if there's some advice I could give to teachers and coaches, it's not to spend all of your time rehearsing the examination and cross-examination of this particular case, but getting used to the art of examination and cross-examination and making argument in a courtroom in every kind of way, not just on these facts, but just generally. Okay, so the mock trial is an artificial environment, and there are certain rules. And the part of the rules is they're supposed to stick to their actual story and not make up facts. So I'm not for a moment suggesting that witnesses ought to go off script and start saying things that they're not, that's not part of the fact situation they've been given. But that said, in the real world, you never know what's going to come out of a witness's mouth. It doesn't matter how many times you've gone through the evidence with that witness, how many times you've asked the same questions over and over. Put them in the witness box, ask them the same question, and they give you a completely different answer. And you need to be able to go with that. And likewise, if somebody's cross-examining and they're taking the witness in a direction the witness hadn't anticipated, sometimes something is going to come out. And a good cross-examiner will jump on that. And that's good. That advances your case and gives that person room to show skills that if the witness hadn't strayed, they might never get to show. So it's quirky that way. Sometimes it's just fluky how one counsel in a case can all of a sudden have a moment because of something inadvertent, something that a witness let slip or something like that. So sometimes, even from one time they've argued the case to another, the team can do remarkably different things because of what the other side did. I think the most difficult part of the moot is the closing. So it's important to pick the person from your team who's going to be the most creative on her feet or his feet. That closing is something you can have an idea about before you deliver it, but it should never be rehearsed. And it's always very problematic if the person delivers a closing that doesn't reflect what just happened, but looks like a cookie cutter. They wrote it, and they rehearsed it, and they delivered it. And it has no bearing or doesn't reflect any variance that might have come up during that particular moot. So that's sometimes a real stumbling block for a team. I think judges are looking basically for the same kind of thing. An ability to deal with facts, be logical, be persuasive, think on your feet, make an articulate argument. Those are all the skills that we're looking at. It's kind of, it's an odd experience for a judge in a way, because we're not used to judging performance. Normally, we set aside whether the lawyer is doing a particularly good job, and we go to the heart of the matter, which is the facts and the evidence. When we're judging a moot, we're doing the opposite. It doesn't matter what we think is the correct legal argument, or whether the case has been proven or not proven beyond a reasonable doubt. We're only looking at the performance of the lawyers. It's kind of an alien thing for us to be doing. But I think we're all pretty much on side in terms of who's been most effective.